Judgment in the matter of Commissioners for Her Majesty's Revenue and Customs versus Taylor Clark Leisure plc.
Lord Hodge will explain the judgment of the court.
This appeal is concerned with a question as to who was entitled to claim from the Commissioners of Revenue and Customs, whom I will call HMRC, the repayment of value-added tax which had been paid in the past by the representative member of a group of companies. Such claims can involve very large sums of money, as an error in the interpretation of EU legislation can give rise for claims for repayment which go back to 1973, when the United Kingdom joined the European Economic Community. Since 1968, European law has allowed the member states of the EEC and later the EU to treat a group of companies as if it were a single taxable person. The United Kingdom took up this option by allowing a company nominated by the group of companies to be the representative member, and by deeming, for the purposes of VAT, supplies of goods and services to or by group companies to be made to or by the representative member. In this case, between 1973 and 2009, Taylor Clark Leisure plc, whom I will call TCL, was the representative member of the Taylor Clark Group, the Taylor Clark VAT Group, which provided bingo and other leisure facilities. In 1990, the group was reorganised and the bingo business was transferred to a newly incorporated company, Carlton Clubs Limited, which I will call Carlton, by an asset transfer agreement. In 1998, Carlton was sold out of the Taylor Clark Group and since then operated independently of that group. Faced with open-ended claims for refunds of large sums of VAT, which taxpayers had paid as a result of a misinterpretation of the relevant EU legislation, Parliament in 2008 passed an act which required all claims to be submitted by a deadline of 1st April 2009. In November 2007, Carlton submitted 4 claims for the refund of VAT, which it alleged it had been mistakenly paid by the Taylor Clark Group between 1973 and 1998. In January 2009, Carlton submitted a revised version of one of the claims, in which it made clear that it based its entitlement to claim repayment of VAT first on the asset transfer agreement of 1990 in relation to claims sums incurred by other group companies before its incorporation in 1990, and secondly, on its status as the company whose economic activities had given rise to the payments of VAT in the period between 1990 and 1998. HMRC's response to the claims shows that there was then some uncertainty as to the correct manner in which to proceed. TCL first learned of Carlton's claim when HMRC repaid to it, as the representative member of the TCL group, the sum claimed by Carlton under one of their claims. HMRC then changed their mind and in a decision dated 23rd September 2010 sought repayment of the sum which they had paid to TCL and refused TCL's request for payment to it of the other sums which Carlton had claimed. HMRC gave 3 reasons for their decision. First, TCL had not submitted a timely claim before the statutory deadline. Secondly, Carlton was entitled to the sums paid before 1990 because of the asset transfer agreement. And thirdly, Carlton, as a company whose economic activities had given rise to the over-declared VAT, was entitled to the sums due between 1990 and 1998. In response to this decision, TCL and Carlton advanced competing appeals before the first-tier tribunal, but HMRC appeared to have settled some or all of Carlton's claims. TCL pursued its appeal. Both the first-tier tribunal and the upper tribunal held that TCL had not made a claim before the expiry of the time limit imposed by Parliament. TCL, however, succeeded in the inner house of the Court of Session, which interpreted Carlton's claim as a claim on behalf of TCL as the representative member of the group. HMRC appeals to this court. In a unanimous judgment, this court allows the appeal. The court interprets the UK legislation which has implemented European law as creating a single taxable person by treating the supplies of the group companies to be those of the representative member, rather than deeming the group companies themselves to be a single entity or quasi-person. A claim for repayment of VAT under Section 80 of the VAT Act 1994 should therefore be made by the representative member or a person acting as an agent of the representative member. For the reasons set out more fully in the judgment and in agreement with the first-tier tribunal and upper tribunal, this court interprets Carlton's claims as having been made on its own behalf and not as agent of TCL. Carlton had no authority to act as TCL's agent in submitting the claims and did not purport in its claims to be acting on TCL's behalf. Thus, TCL did not make a timely claim and its challenge to HMRC's decision fails. TCL applied to this court to invite it to make a reference to the Court of Justice of the European Union on the question of the nature of the single taxable person. This court declines to do so because a ruling on that issue by the CJEU is not necessary for the determination of this appeal.